So welcome to the webinar today. This webinar is co-hosted by USC Marshall's Initiative on Digital Competition and Seoul National University AI Policy Initiative. My name is Yong Lim, and I am the director of SNU AI Policy Initiative, and I will be moderating the webinar together with Professor Hyo Kang at SNU's Business School. Today's webinar focuses on recent developments in Korean platform competition and regulation. And as everybody knows, the KFTC came out with a new legislative proposal last month that did depart from its initial or previous position on platform regulation, namely moving away from a designation scheme to a presumption-based regulation of platforms. And it also selected 6 service sectors and identified 4 categories of conduct that it would specifically target through the proposed law. Now, there has been a lot of reactions, both positive and negative, on this new proposal. The KFTC hasn't released its text yet, but there is a lot of definitely issues that we can and should discuss. So this webinar will try to do that today. And we have a stellar list of panelists, and I will briefly introduce them to you. So Sujin Nam is an associate professor at the International Economics and Law Department of Hankuk University of Foreign Studies in Seoul, Korea. She was a visiting scholar at USC during the past academic year. Hyuna Kim, our next panelist, is a partner at the Korean law firm Bae Kim & Lee and has a wealth of experience in antitrust law spanning over more than 2 decades. She had served in various leadership and advisory roles, including vice chair of the IPBA Antitrust Committee, and is currently a member of the IBA Antitrust Committee Cartel Working Group. Our third panelist, Hwang Lee, is the current dean and professor at Korea University School of Law and a director at the ICR Law Center. His academic interests covers competition law, intellectual property rights, among other things. Dean Lee was recognized as a leading antitrust academic by his peers in GCR's 2022 survey. And last but not least, Youngjin Chung is co-chair of Kim and Chang's antitrust and competition law practice, where he has represented major global tech companies in various cases. He also leads the firm's international trade practice and recently published a book on international merger control titled Competition Law Regulation in the Era of Deglobalization. So we have definitely a wealth of experience and expertise in the panel, and we look forward to having a very lively and informative discussion. So Hyo, I'll hand it over to you to start off the discussion. Hyo, I think you need to unmute.
Oh, thank you. Hello, everyone. My name is Hyo Kang Hyo-seok, and I'm an associate professor at SNU Business School, where I joined just last month. And before coming to SNU, I spent 5 years as an associate professor at USC Marshall, and I continue to serve as an affiliated faculty at USC Marshall's Initiative on Digital Competition, which is one of the host institutions today. So a little bit of the background again. The Korean FTC announced its new policy on platforms, shifting from an ex-ante designation-based scheme towards an ex-post presumption scheme in determining platforms with the market dominance. And it will also regulate the 4 different types of conduct abusing their market dominance. However, Concerns arise as the new approach may simply sacrifice the advantages of predictability provided through the ex-ante designation scheme, while still suffering from the disadvantages of that, namely the chilling effect on innovation. So my first question is for an attorney, Jung Young-jin. So EU Digital Markets Act has two different pillars. One is the designation of platforms, and the second is the ex-ante prohibition of the conduct. So should we view the two regulatory tools go hand in hand with one another, or as the two sides of the single coin?
Thank you. Thank you, Professor Lee, for a nice introduction. And then, Professor Kyo for the intro remark. There have been a lot of discussions, and then, if I will, first about the distinction between ex-ante and then ex-post regulations. Apparently, KFTC proposal adopts a legal presumption scheme as part of the ex-post antitrust enforcement vis-a-vis ex-ante regulations, epitomized by the so-called designation process. It appears that the KFTC's proposal may be viewed as not a typical ex-ante regulations, in the sense that they have a legal presumption, not having a designation process. But apart from this semantic categorization, ex-ante, ex-post categorization, the KFTC proposal aims to have the similar effects as designations. Once enacted, of course, we need to see how the implementing regulations will be framed. But KFTC would conduct a market survey once this new piece of legislation is enacted, and have a list of companies subject to legal presumption for dominance. So if this is the case, KFTC's proposal would have a similar issues that business are concerned about as ex-ante regulations. I think that there are multiple paths for what we call the preemptive antitrust to deal with a unique challenges in the digital market. First, EU DMA, as you all know, is the strongest ex-ante regulation. Designation, plus no need to show anti-competitiveness. It explicitly states that there is no efficiency defense, plus periodic compliance report obligations. So by all indication, it's just a sectoral regulation applied to digital platform market. As for UK DMCCA, it's a bit less stringent than EU DMA in the sense that it will tailor the behavioral obligations to individual companies after some market survey. However, the framework is all the same. Designation plus no need to show anti-competitiveness upfront, plus periodic compliance report. Producing compliance report is a huge undertaking. I looked at some of the public version compliance report is more than 300 pages. As for the German competition law 19A, the least stringent of all three. Of course, this has a component of designation, but it has to show the anti-competitiveness. No automatic your probation, unlike in EU DMA and others. And then there is no specific obligation for periodic compliance report. So German competition law is not a typical ex-ante model, but an extension of a traditional competition model, although it has some element of designation, but the very fact that the competition authority has to show the anti-competitive effects is more or less falling under a traditional exposed antitrust model. According to Draghi report, especially in the section of revamping competition section, it proposed a combination of ex-ante regulation and exposed enforcement. It also states that ex-ante regulation should play a supplemental role, not the mainstay of regulation on antitrust. So, I think there are multiple ways to address significant and persistent, even structural antitrust issues. We should not think that KFTC should strive toward effectively making current proposal as ex-ante regulations such as EUDM. I'll pause it here. Back to you, Professor Kim.
Thank you. Thank you for sharing your insights. Do you have any comments or questions from the panelists? So, okay, if not, for the interest of time, I will move on to the second question, but we will have some Q&A sessions at the end of the session, and we have 7 more questions awaiting us. So the next question is a bit more on the designation process. So the next question is for Professor Yi Hwang. The designation approach is actually based on the gatekeeper status or the cross-market significance. So how is it different from the conventional dominant market position approach? Is it just a matter of degree in terms of the market share or control, or is there any fundamental difference between the two concepts? And why are they important to competition policy?
Okay, thank you, Professor Kang. I think there are some fundamental differences between the notion of a dominant position as adopted in conventional antitrust laws that assumes a given definition of relevant market. And the difference is that the gatekeeper adopted in the ex-ante regulatory scheme, as we have seen in the case of EU, it is concerned about the economy with the cross-market impact. So the notion of gatekeeper seems to implicate a broader range of business players in the scope of digital platforms, given the business's field of multi-sided market of global range. Differently, the notion of a market dominant position is supposed to be devoted to the enforcement of conventional exposed antitrust regulation. It is typically designed and works to screen out small and excessive numbers of potential cases by small businesses that are not considered to have capabilities or possibilities to restrict market competition. So I think the difference between the two notions seems to have something to do with the background or actual concerns of ex-ante regulation. So what is behind the concerns about big tech? I think, as Mr. Jung already stated, there should be something that can justify the sacrifice of efficiency that has pursued by the traditional antitrust laws for a long time. So the concern may be something more than just market concentration. So in the case of EU, in addition to the official justifications of overcoming limitations of conventional and existing antitrust regulations, the EU reclaimed that it is important to achieve digital sovereignty against global or American big techs. So it goes far beyond the traditional efficiency goals that the existing antitrust laws has considered the most important. Very similarly, in the United States, the new Brandeis School, they argue that they want to pursue the economic, political, and social reasons that has not been adopted in the regulatory scheme, the regulatory scheme and tools of the traditional antitrust laws. So in Korea, I think it is not clear what should be the justifications of a possible ex-ante regulation, because in Korea we already have extensive regulatory tools of ex-ante regulation. For example, we have a diverse regulatory tools of the general concentration. We have various tools of regulation over the so-called 갑질 or abuse of a superior bargaining position. So I can say that the KFTC is already equipped with the most powerful range of regulatory tools. So the new introduction of other weapons, as we have seen in the case of EU or UK or Germany, I think it is not necessary at the present time. At most, we can achieve a same result by strengthening existing antitrust laws if necessary. Well, in this sense, I agree with the recent announcement of the KFTC, and they say they give up the introduction of a regulatory scheme of ex-ante regulation or ex-ante designation of the big techs. Thank you.
Thank you. Any quick comments or questions from the panel?
Dean Lee, I have a quick question because you're also a former KFTC official, and I wanted the audience to perhaps have an opportunity to accurately understand where the KFTC stands right now. So the KFTC in its new proposal stated that it would target, it didn't use the word gatekeeper, but it did say that it was going to target, you might say, literally overbearing market dominance platforms. So when we say overbearing market dominance, now it did say 60%, well, it did up the concentration ratio a bit, but does that mean then, would it be something similar to a gatekeeper, or is this just more of a stronger dominant position? So where does the KFTC currently stand between those two, the spectrum of quote unquote market positions?
Very good and interesting question. My answer is that I don't know. It should be something in between the traditional dominant position and the gatekeeper as adopted in the European DMA, but because they did not disclose the actual provisions of the amendment of the Korean antitrust laws, well, I'm not sure about what they actually have in mind. So, but what I can say is this is something between the two notions given.
Right, thank you so much. So it seems that the gatekeeper concept is fundamentally different from the market dominance, and we need more than just market concentration. So back on the track of discussing the designation part. So my next question is directed to an attorney, Kim Hyuna. So there are two main approaches to regulating the designated platforms. I think the first one is to establish a very high level general comprehensive principles, or the second, specifying an individual menu of prohibitions or rules. And there can be some place in between. So could you please share your views on what legislative approach will be optimal for regulating platforms and their competition?
Thank you, Professor Kang, for the introduction and the excellent question. Before moving on into detail, for those of you who are not familiar with the Korean competition law, I will give you a very high-level explanation on the structure of the current legislation. And firstly, as mentioned by Professor Hwang Lee, KFTC has the multiple tools to regulate online platforms already. So we have this unilateral conduct prohibition, both abuse of market dominance like in other jurisdictions. And we also have these unfair trade practices as well. So, and on top of that, KFTC has its own review guidelines for abuse of dominance, unfair trade practices, and it issued special guidelines for online platforms as well. But there are multiple tools and layers of regulations already on place. And in terms of the legislative approach, whether it's comprehensive or specific prohibition, I think the current Korean legislation is a hybrid of the two. Basically, we are in a specific prohibition regime in that the highest level of legislation, our primary competition law, Monopoly Regulation and Fair Trade Act, the MRFTA, lists of specific conduct categories in it. For abuse of market dominance, there are 5 specific conduct categories. And unfair trade practices, there are 9 specific conduct categories. But there is also one catch-up provision for unfair trade practices. And I'd like to focus on abuse of dominance for today's discussion. So there are lower role for the MRFTA, there is an enforcement decree. In the enforcement decree, there are 2 types of conduct categories. For 3 conduct categories, we have only the specific prohibitions. But 2 other conduct categories, there is a general provision. But there's also a hybrid of the 2. There's a specific prohibition and one general provision as well. These 2 general provisions are supplemented by the KFTC's review guidelines, and KFTC's review guidelines for these 2 conduct categories provides 4 specific conduct categories. And there is a 4th conduct category, seems like a catch-up provision, but it's again limited to very specific conduct categories in 4 and 6 and 4 respectively. So all in all, it seems like we have taken a specific prohibition approach. And KFTC's online platform guidelines, new guidelines, also has this specific 6 service sectors and 4 specific conduct categories. And the 4 conduct categories, although it seems new on its face, other than tying, so it's restriction on multi-homing, forcing MFN, and self-preferencing, all these 4 again fall under at least one of the existing 5 conduct categories under the law. So up to now, we have this specific prohibition regime supplemented by the general provisions. So we see historically these broad provision like exclusionary conduct or the undue interference with business activities are applied to new types of conduct in emerging industries. So I think the proposed amendment by the KFTC is not different from what we have seen so far. For example, in industries like new industries, KFTC starts its investigation and imposes sanctions. And these precedents are included in its review guidelines. And we see more clarity in these review guidelines. And KFTC's recent try to amend the MRFTA is like a path to these guidelines, show adding up to the higher level of legislation included in a low level. So personally, I think the target areas and prohibited conduct remain the same as in the current online platform guidelines. It sees the more higher level of legislation and same as the hybrid of comprehensive and specific prohibition. So I think there is a new need for this new legislative structure for the online platforms only. So I think we are on the path, the same historic path as the KFTC has done to achieve both clarity and flexibility in its legislation.
Okay, any quick comments or questions from the panel?
So I have again another follow-up, and I think I mean everyone would agree with you in terms of, well, what's really new, right? It's the six service sectors, the four conduct categories, they're all already in the current online platform guidelines, which are actually being enforced by the KFTC in the Kakao mobility case, in Naver, in Coupang, etc. So that begs the question of, well, why then this legislation, right? And as you said, it does elevate this quote unquote internal guideline into actual law. And I think the KFTC chairman, Han, recently said, or he emphasized that the real purpose was to speed up enforcement. The logic was that this would help the KFTC to push cases forward more rapidly in a more timely manner. And my question to you as a practitioner on the ground, do you agree with that assessment? Do you think that elevating these rules into actual law from guidelines, would that make a difference? Does that really change the game? Your views on that?
Okay, thank you for the good question, Professor Im. As a practitioner, I understand the chairperson of the KFTC remark that he wants to expedite the investigation process. But as a practitioner, we've seen these in the past as well in similar cases where the KFTC escalated its guidelines onto the law. In terms of due process rights, there has been new development and improvement on it. But I don't see any change in speed of investigation. It really depends on the will of the agency and how well equipped they are. But sometimes in our situation, it is affected by, political situations or complaints by small business owners or other consumers. But I don't think the change in the level of legislation will affect the speed of investigation or result of the investigation. But one thing we have concerns is it is new provision on the possible injunction order by the KFTC. It's one feature of the KFTC's amendment proposal, which is similar to ex ante regulations. So if he has something, injunctive order in mind, I think it has some effect on possible speed of enforcement or correcting the anti-competitive harm in the market. But other than that, I don't see any much difference. That's my question. That's my response. Thank you.
Thank you. I think with the uncertainty around whether a specific platform will be considered or presumed as a dominant platform, coupled with so all the other things, including the burden of proof transition, I think it'll be a really interesting, important issue. And I think we will have further discussion in the later questions. But let me now move on to the fourth question to Professor Nam Soo-jin. So I think there are many different policy goals, tools, and levers for regulating platform. And I think they include promoting competition, or protecting privacy and data, or protecting consumers, supporting small businesses, and preventing unfair practices in the market. So for example, in Korea, I think the previous government highlighted the addressing the unfair trade practices, while the current government is focusing more on the promoting competition in the market. And then the EU Digital Services Act, DSA, also covers a range of topics. So in your view, Professor Nam Soo-jin, which area of the platform regulation that the competition authority should prioritize?
Well, thank you for Professor Lim and Kang and also Professor Sokol for having me here. It's an honor. So the question is an important one, and I'm not sure if I am, equipped to answer and sort of juggle which policy should, get the priority it deserves. But what I wanted to say was two things. So because of pervasiveness of platforms, I think there are many, many important issues that arise. And just because I teach undergraduate students, I, often conduct survey on my students and ask them if the generation that, supposedly are most used to these types of platforms and hence can maybe benefit more from the use of these platforms, are keenly aware of a lot of the issues. They feel very strongly about data privacy, interoperability with their walled garden devices, ads on platforms and how expensive it is to remove ads. And they feel very strongly about it. And I think most of the policy priorities that you listed in your questions deserve attention. Um, Today in Korea, I wanted to highlight that the hot issue, although there are hot issues everywhere, really the hot issue I feel is that there are COP2-related grievances from mostly self-employed restaurants who complain about certain practices conducted by the very successful Korean delivery platforms. And when NGOs and civic groups survey on platform abuses, most complaints do relate to the platform's treatment of its business users, whether it's e-commerce platform or delivery platforms. And since it has a lot of, political implications, I think a lot of resources are focused on those 갑질 abuse of superior position type issues in Korea. One thing I also wanted to note about that, which is I find particularly interesting, is that the KFTC, which is not only a competition authority, but it has other laws and objectives under its mandate, has actually been playing a role in collective negotiation process between the small mom and pop Korean restaurants who are complaining about the commission rates of Korean delivery platforms and the online platform. So they are sort of collectively negotiating on the appropriate rates for delivery. And I find it interesting that the KFTC, which also has the hat of perhaps fighting against collusive practices, are sort of leading maybe not leading, but are involved in a process where the competitors from the industry are getting together to lower rates. My understanding is that currently the delivery platforms are offering staggered rates because the complaint is based on the previously very high rates. So they are now offering an alternative to that. And the reports from the news keep saying, well, there are, a couple of delivery platforms who are okay with that. There is a holdout of that approach, which makes this collective negotiation difficult, which seems to suggest that there's certain pressure to get everyone together to kind of settle on a lower commission for the restaurants. So that is something that's notable, I think, that's going on in Korea. What I think personally, as a second note, I think is important for long-term economic development and competition is in Korea is really the question of access. I think, protecting reasonable access to key platform services and technologies is very important, especially with online platforms that hold major technologies such as AI technologies, and that continued scrutiny is necessary on blocking reasonable requests for access and exclusive dealing agreements. And I also am open to interoperability measures that may be required by law. But this, I want to make sure that this is not something that I think competition law should be in charge of. I think it's more new law or regulation that may be the better solution for the access problem. But I personally think it is something that has a role in competition policy. Not all, but it has some role, and I personally think it's really important going forward into the future that we have healthy growth in our digital sector. Thank you.
Thank you. Any quick questions or comments from the panel? And I personally think that access issue that you mentioned, just mentioned, will be increasingly important. And I'm really curious, like, who will be the right authority to regulate or govern all these kind of issues? And I look forward to hear more from you if we have some time at the end of the seminar. But with that, I will hand over my mic to Professor Im Yong.
All right, so Sujin, I'm going to direct another question to you, and it's in a sense related to your first intervention. Now, as you know, the recent spate of Google cases, including the search antitrust case in the US, actually focuses on exclusive dealing and access. And so maybe there may be some movement there related to competition. But going back to platform regulation, based on your identification of the 갑질 issue and access, do you think that the KFTC's proposal to focus on, as Attorney Kim pointed out, tying MFN, self-preferencing, etc., or multi-homing restrictions, do you think that the focus is sufficient, or maybe are there any other practices that the KFTC or regulators should put their focus on?
Yeah, thank you for the question. Well, I think based on what Ms. Kim has already addressed about how the existing laws have covered these conduct, and existing laws, they don't necessarily spell out self-preferencing, but they have been used. So the KFTC has a history of interpreting their statutory basis quite broadly. So if you're asking if this list is complete enough, I am tempted to say with what's there, it may be interpreted very broadly to cover conduct that are related, but not something that might, fit just. It's not the conduct that we imagine when we hear the word multi-homing or self-preferencing. It might be something that could be interpreted as such. And I haven't looked at the text yet. I don't think we have, but the press release seems to include the word etc. In many of its places. So I wonder if this is not just their complete and final list. They may add something else. But yeah, as you mentioned, if I had to think of something, I did think of exclusive agreements, as you said, based on the Google case in the US, and also because of the focus on self-preferencing. Now that these big tech companies are not allowed to use their internal divisions to basically do business, I wonder if they will establish long-term partners that are outside of their company structure to kind of continue to do what they do in terms of what we refer to as self-preferencing. And those will come as in the form of exclusive agreements, etc. So that's something that I think is important. Another point I wanted to address about access was the law on refusal to deal. It's something that I feel like a lot of agencies want to use and expand, but have difficulties doing. And in Korea too, in terms of abusive dominance, refusal to deal is very difficult. It has high standards as outlined by the POSCO case. But Korea, as Professor Lee mentioned, we do have refusal to deal under unfair trade practices, which I think presents a lower bar. And it's something that is not within the framework of the proposed amendments because the amendments only address the abuse of dominance. But I think it's something, a tool that has, has a lot of potential. And it's something that I also wanted to include. While it's not covered, it's something that that is important, in my opinion, going forward. Thank you.
All right, so for the benefit of time, I'm going to go on and move on to the next question, but we will have an opportunity to react and discuss later. So I'm going to direct the question to Dr. Chung. And this relates to privacy and competition. And so we did discuss a bit about privacy being another sector of platform regulation that is important. And there are debates whether competition law should or should not have a say in what and how much privacy should be protected. Now, there are various approaches to handling the relationship between competition and privacy. And as you saw in the Bundeskartellamt Facebook case, now there is, the European position is that the competition authority can consider violations of privacy law, GDPR, but it does also have to do a competition analysis. And so setting aside, the propriety of competition intervening into privacy-related policy or setting privacy protection as one of its goals, I think we also need to think about jurisdictional issues between different agencies. And so, for example, in Korea, there is the Personal Information Protection Commission, and there is the KFTC. And so if the KFTC were to, in the name of platform regulation and competition, opine on or incorporate privacy-related concerns into their enforcement, how should or how could they manage the relationship with the PIPC? What should be some of the guardrails or guidance that you would give or suggest for those two agencies? Dr. Zhang, I think you need to unmute.
Thank you very much for your excellent questions. I think that this is uncharted territory. People have been thinking about this issue of intersection between antitrust and privacy regulations. As you know, data, privacy law and antitrust law are distinct legal disciplines. Data privacy doesn't really fit neatly with the antitrust and other existing doctrinal areas of law. The overarching goal of antitrust is competition, and goal of privacy regulations is a preservation of personal integrity. So distinct legal disciplines have evolved without really much regard to each other. But as you pointed out, German Bundeskartellamt took an issue with the Facebook's cross-platform data aggregation. And then if you look at the European Commission's EU DMA, you have multiple components about addressing the privacy practices in the Article 5 and 6 of the EU DMA, and then also UK DMCCA also has some elements, and then even German competition law also has some element in it. So there have been a recognition that there have been certain areas where competition law plays a role, but like I said, we need to think about what the role each agency should play. The Korean Privacy Information Personal Information Agency has already demonstrated its abilities to address some of the important privacy practices questions. And if you look at Korean privacy regulations, you have some element regarding the data portability issues. So, I think that we should not assume that there are a lot of the areas where competition law plays a role in addressing some of the issues related to privacy related competition. Even take an example of the German Bundesamt case regarding Facebook. It's not really pure, as you know, pure antitrust case. You made a reference to GDPR, and then the way the German competition law is structured is to address a specific situations relating to other areas of law. So that's where the case came in. So in Korea, we need to think about, from governance perspective, we need to think about how both agencies can work together to address the unique challenges privacy practices would present, rather than just in some other legislative proposal pending National Assembly. There is a reference to privacy practices following the model of EU DMA. In the legislative proposal, I think that we need to think further about what each agency can play, given the track record of their enforcement for now, and how these two areas will evolve in the future.
I think it's going to be particularly challenging, as you said, when multiple agencies meet on an issue. For example, the European Court said that the DG Comp should listen to or consult with the GDPR authorities on whether there was a violation of privacy. And then the question immediately becomes where can they have a different opinion, for example? And it's not a black and white issue. For example, the severity or the depth of harm, that there may be differences there. Does that factor in? How should that factor in the differences of opinion? I think that's all an issue that will be ongoing in terms of also scope and breadth of competitive harm. So I think there's a host of issues, as you pointed out, that are not clearly articulated or determined as of now. I'd like to move on to Ms. Kim, and I think this actually nicely ties in with a point that you raised earlier in terms of speed. So together with injunctive relief, I think another at least hope from the KFTC was that burden shifting would result in expediting enforcement as well. And so, and that relates to establishment of competitive harm. And there are several approaches to establishing anti-competitive effects. Once again, the traditional, the competition agency has to prove everything. So that would be the traditional approach. There is also a new approach that is being pushed by shifting the burden of proof to the platform operator. Or, for example, there could also be an approach of lowering the standard of proof while still placing it on the competition agency. And I suppose there would be other approaches as well. So if the KFTC goes ahead with this platform law or some form of platform regulation, do you think, or should the KFTC, to be effective? Now, granted, there will be some adverse effects or some concerns there, but to be effective, should the KFTC change or adjust the burden of proof if they were to transition to something more akin to ex-ante regulation, or if so, what changes would be necessary?
Okay, thank you, Professor Im. As a conclusion, I would like to say that ex-ante regulation does not always mean the shift of the burden of proof to online platforms. And I'd like to compare these three types of legislation we have right now. First of all, the EU DMA, as many people understand, they're a very high standard, lower standard for the platform operators. The burden of proof is basically shifted to the platform operators in terms of the ex-ante designation of gatekeepers. Why is it? Because it's basically based on quantitative thresholds, whether it is a core platform service provider or annual turnover or active users. Those are, the quantitative thresholds are easily proved by the competition agencies. And there are also some exceptions. The rebuttal by the platform operators are allowed, but they have to prove exceptional circumstances not to be designated as a gatekeepers. So it's basically the burden shifting by the competition agencies. And EC may still designate other platform operators, although they do not satisfy all the quantitative thresholds. So there is plenty of room for the competition agencies. But in contrast, the new law issued by the UK CMA, the DMCC, the Digital Markets Competition and Consumer Act, although it follows the same ex-ante designation of a company with a strategic market status, so-called SMS, it has taken a different approach. So it does not follow the quantitative threshold. It is basically the qualitative assessment of the market power. And with one exception, there's a minimum turnover threshold, but basically it is all related to the substantial and intrinsic market power of a company. And I think that the interesting thing is that along with this designation of code of conduct, it is specifically linked to a digital activity by a company, not a general provision. So the competition agency took the burden of proof on either whether it is SMS or what kind of conduct should be included in the code of conduct, or bears the burden on the competition agencies. The proposed amendment by the KFTC, although we haven't seen any details of the draft bill, I think it's similar to the current presumption of dominance with a higher bar of quantitative thresholds. We don't know how it will be specifically dealt with in the draft bill, unless it designates some list of companies. I think it will work very similar to the current system of presumption of dominance under the MRFTA. But with the exception of this minimum turnover threshold and number of users, there's a new standard, but I think basically it will be similar. And KFTC has the burden of proving, especially the key here is how to define the relevant market and assess the market share and market power. So I think it's in line with the current legislation, but we will see how it differs from the current legislation when we see the actual bill. And I think personally believe the burden of proof for anti-competitive effects somehow should lie on competition agency, because we are not dealing with the industry regulator, but we are dealing with the competition agencies. So we may lower the standard of burden of proof, but still at least some some part needs to be proven by the competition agency. But in EU DMA's case, as Dr. Jung mentioned, critically shift the burden of proof by requiring compliance reporting from designated gatekeepers. But as I mentioned, UK DMCC takes a different approach, but they are the one who sets up the code of conduct for specific enterprise for specific conducts. So as you mentioned, in order to have the efficiency only, KFTC may take the route to lower the burden of proof for these super dominant firms in online platform areas. But I think at least some part of burden of proof should be on the KFTC, and platform operators will be given the opportunity to rebut. But I don't know what they mean in their press release that the operators will be given sufficient opportunity to rebut. So I'm also wondering how it will be crafted into the actual bills. That's my response. Thank you.
Thank you for those insights. I think all of us today agree that there is really a lack of clarity right now, just based on the press release. And Dean Lee, as a final question, I'd like to actually pivot from what Ms. Kim had just said, based on ex ante, ex post, and all that. So clearly, it's not really clear whether Korean platform law proposal by the KFTC currently stands, whether you could actually confidently categorize it as ex ante or not. It certainly does have the potential to be wielded like an ex ante approach, as Attorney Kim and Dr. Jung pointed out. But nonetheless, I think ex ante and ex post is really a hot topic right now around the world, and I think it's actually prodding competition agencies to reflect on who they really are. And there's a question of, well, the traditional ex post competition agency evidence-based approach didn't really work that well, at least for digital markets, and so we should move now towards a more regulatory agency approach or something more hybrid. And so you have these law proposals coming out and trying to hand these agencies with new tools that look more like a regulatory agency. But if we are going to transition, or at least you might say evolve into sort of a new digital markets related entity by a competition agency, what do competition authorities need to do to effectively adapt, undertake the necessary changes, and really do a smart and do its job well? I think you have to unmute.
Okay, thank you very much for the very good question. Of course, and you said, competition authorities should adapt to the new role, and the capabilities required to enforce new ex-ante regulatory tools about digital platforms are quite different. I think that ex-ante regulation of a specific industry will typically require more expertise and experience in the given area than as in the case of the existing characteristics as a general ex post regulator for a competition authority. As a rule of thumb, general competition authorities do not typically have technical expertise over specific industry. Particularly, the business of digital platforms involves a wide range of cutting-edge technology, and regulators are expected to understand the characteristics of that industry. And given the complexity of the digital platforms that works with on the basis of artificial intelligence, big data handling, and various hardware, including semiconductors, competition authorities should expand their expertise in that field. And one of the most important resources they need should be the professionals who truly understand the industry. I want to emphasize the skill to communicate with other sectoral regulators and society and general citizens. And one of the concerns of the ex-ante regulation over digital platforms is the increasing concerns of the general concentration that may undermine various interests beyond economic values. For example, the democratic political system or economic and political sovereignty. And to perform such a mission that is very new to existing antitrust authorities, they will need to communicate effectively and efficiently with the corresponding industry, society, and even politics. And there is quite different characteristics and expertise they have so far. And focusing on the case of Korea, as I said, the KFTC is not a simple competition authority already. According to the Korean antitrust law, the KFTC is expected and mandated to enforce 3 different fields of regulatory works. One is the conventional antitrust, and 2 is the regulations of the general concentration. Number 3 is the regulation over the 갑질 or so-called ASVP. And the ASVP has been particularized and reflected in several particular enactments like the subcontract law, franchise law. So there is quite different characteristics from any other antitrust authorities in the world. And it suggests that the KFTC already have significant abilities and experience of over 40 years that are required by other sector-specific regulators. So the KFTC can be considered to be in a better position than most of other competition authorities in the world. But in any event, the KFTC and other antitrust authorities, they have to learn and adapt to the new environment, as you have suggested. Thank you.
Thank you. So it is over 12 p.m., but we did start a few minutes late, and I understand that there is also a question from the floor. So Professor Kang, I'll hand it over to you.
Okay, so let's briefly talk about the question from the participant, which is, does the Korean government's platform or digital-related policy tend to follow global trends aligned with those in EU and in the United States, or does it try to stick with the local needs? Any responses from the panelists?
Maybe I can add a line. I think it is half and half, and many critics in Korean academics, they have a view that KFTC is excessively intrigued to follow the so-called the Brussels effect. So their proposals to adopt a new ex-ante regulation over digital platforms are based upon a foreign demand rather than a local demand. So many have argued that KFTC should listen to the local industry and local demand for any new regulations. So I understand that the KFTC have listen to the voice. And recently they have announced that they will give out the introduction of the peer ex-ante regulation. So I totally agree with the new attitude of the KFTC. So, but we again we have to understand that we have a very strong local voice from the small and medium firms and the consumers in the Korea that argues a strong regulation over the abuse of powers of the large market dominant platforms. So I think that my answer is the half and half, and the KFTC has a very difficult mission to solve the potentially conflicting goals. Thank you.
This is Young Jun. If I may, I just want to supplement what the Professor Lee had to say. Other people are saying because of the process effect, as Professor Lee mentioned, different countries are trying to adopt ex-ante regulations on the platform. But if we look a bit closely into all of these laws, all of these laws are adopted to reflect upon what is needed in the particular jurisdictions. There are a spectrum of the ex-ante legislations, as I explained, and then all the participants explained. The EU DMA, UK DMCCA, and then German competition law 19A, and the Japanese smartphone sector legislations, and then the one that KFTC proposed. They have a different needs, local needs, to reflect upon the direction of the ex-ante regulations one from another. And then one final thought I might add, this is related to Hyona's observations about the practical implications of the KFTC demand, the legislative bill. I think of course, you're right that because existing laws are already addressing the issues in the draft bill, but practical implications of the KFTC bill, would be, from my standpoint, is that if the burden is shifted to parties, I think all ex-ante regulation is one from another is burden shifting. Then, the parties are pressure to cooperate with the regulators to, get themselves off the hook. So the entire process of defense by the parties will be quite different, and then it will have long-term implications for the companies subject to these regulations.
Thank you. So we are now over time by 12 minutes, but I didn't want to end things without giving Attorney Kim and Professor Nam a chance to reflect or at least make their final comments. So Ms. Kim or Professor Nam, any departing comments that you would like to make before we wrap up?
Oh, my last comments is that I also agree with Dr. Zhang's comments that the burden shifting will affect the defense strategy and the future business of the possible subject of the investigation by the competition agencies. And we'd like to see that the specific draft of the KFTC's, as soon as possible to analyze the actual impact of how burden shifting will occur under this quasi ex ante. I don't know whether it's ex ante or ex post enforcement, but I'd like to see the actual bill and what the specific ideas the KFTC has in mind. Giving these super dominant firms act, it only says that more than 75% is usually not the super dominance, but it does not mention anything about the competitive effects of these firms and how it will be, it may lessen the burden of proving the anti-competitive effects of conduct by such super dominant firms. So we are very unclear about the KFTC's enforcement direction, although we have this press release by the KFTC.
Thank you, Professor Nam. For some reason, I'm not hearing you, but maybe you can try. Okay,
yeah.
there you go.
Thank you. No, I just said, I don't have any further comments. We're already over time. Thank you.
All right. So again, there were a lot of nuances that came out today, and I do want to spend at least 1 or 2 minutes distilling this for the benefit of the audience, because it's rare that we have an opportunity to get these 4 on the same panel to discuss. So I think what the panel discussed today, everyone agreed that it's difficult to characterize or pin down what the KFTC's approach actually is. So one thing for sure, and everybody agrees, is that it does try to move away from an EMA, DMA, EU type, really pure ex ante push type of regulation. At the same time, I think, as Dr. Jung and others pointed out, the way that it's implemented does have or could have the results that closely mirrors what an ex ante regulation would or could be. Another point that came out today, and I think it's very important, is that you really heard how the KFTC actually does act like a quasi-regulator already, how it already does have a lot of tools. And as Professor Nam pointed out, it does focus on policy issues that would traditionally be viewed as outside the purview of a conventional competition agency, for good or for worse, basically reflecting the realities of what is happening on the ground in Korea. So as the panelists pointed out, the KFTC is currently grappling with this. And I think what it actually shows today, I think probably the takeaway point, the most important point, is that the KFTC has not finalized the text. As I understand, it is still working on it. It is still, will be going through multiple rounds of review, also feedback from outside. And so we'll have to see how things shake out. I think discussions like today and insights that are provided through these fora and other opportunities will be important, in the sense that we're all trying to see what is the proper approach for Korea. So definitely, as Dr. Jung and others pointed out, Korea does need a different approach. I think also everybody, as Dean Lee was also pointing out, that Korea does want a different approach. But what is that approach? What should be done? And how to actually specifically spell that out, as Attorney Kim was requesting, will be a challenge. And so we hope that today's discussion does contribute to that discourse. And again, we are very grateful for the initiative taken by the USC Marshall Initiative for Digital Competition in bringing us together. And we at SNUA, a policy initiative, was very honored and pleased to co-host this webinar. And with that, I'd like to thank our excellent panelists again for their discussion, for their insights, and we hope that we will have future opportunities to hear from you again. Thank you very much, everyone, and I apologize for going over time. Thank you very much. Cho, do you want any final departing remarks?
So thank you.
All right, so we'll see you again, and thank you very much.
Thank you. Bye.
Thank you.
Thank you.